Applying Gender Politics with Children, a review of the Ministry of Justice Harms Report. This is the so-called Harms Report, some 400 pages published by the Ministry of Justice last year. The report says that there is a pro-contact culture in family court. This is, of course, actually the law, not the culture, as articulated in the Human Rights Act, the United Nations Convention on the Rights of the Child, and in countless decisions at the highest levels of our courts. This, as we'll see in the rest of the report, is a word game. They're using the term culture to pretend a power they don't have. The ministry has no right to change laws, but changing culture seems normal. But we have to remember that the culture they're talking about is actually the decisions made by the judiciary, and that is, practically and effectively, the law. The civil service executes the law. That is its culture. They say that the law is leading to outcomes that are potentially unsafe for children and adults. But the only basis for this claim is the ministry's wholly unreliable survey of women's feelings. No actual data was looked at all. It claims the proportion of false allegations of domestic abuse is very small. But the one study they used to support this, which was an analysis of custody cases in Oregon in the United States, actually indicates that in UK family courts, false allegations outnumber true allegations by 2 to 3 times. It claims that supervised contact merely puts abusive behaviour on pause, but its only reference for that actually indicates the opposite. Most worryingly, the report asserts that there is no automatic right to contact between a parent and a child. This is an extraordinary statement in violation of the Human Rights Act and the UNCRC. Do you think you have the right to hug your child? The Lord Chancellor doesn't think so, at least not without some form of parent. Put together, the report represents a recipe for parental removal based on unfounded allegations. The government has commenced re-educating of our justice staff accordingly. The report certainly looks official. It has the ministry logo and the insignia of the Crown. You might easily be forgiven for thinking this was a report of the government. However, when we asked the Ministry of Justice about it, they said it's not their report at all. The actions of government officials are regulated to avoid bad practice. Civil servants are regulated by the Civil Service Code, the Lord Chancellor by his oath of office and legislation, and this ensures that the public are reliably informed about the data held by the government. However, in this matter, instead of using civil servants, the Lord Chancellor created a panel from outside the ministry, and rather than use real data, it compiled unverified anecdotes from the public, and then the Lord Chancellor published them as if it was the product of the government. If the Lord Chancellor claims his structural acrobatics have avoided any requirement to follow the Civil Service Code or any other professional standards, it shows in the product. What does assessing risk of harm mean? Considering the aim of the report was to assess risk of harm in private proceedings, you might think it would examine such issues as how often does domestic abuse actually occur before, during, or after proceedings? What is the type and severity of the abuse? Are these cases of violent battery or nasty text messages? What is the effect of this behaviour on children? Are they even aware that mum or dad has received a nasty message, and if so, who made them aware of that and why? Do events of abuse clustered around the time of separation have any bearing on the parenting capacity of either the accuser or the accused? What has been the actual effect on the accuser? Have they had any need for therapy? How often are allegations false or trivial? What is the effect on children of false or trivial allegations, considering that in many cases, an allegation will cut the child's contact with one parent, often a stable, loving and engaged parent, whilst the allegation is considered? What is the effect on the accused? One might consider suicides, loss of employment, and mental health effects of being accused and shamed whilst losing the love of one's children. What are the overall benefits of contact? Contact, even with known perpetrators of domestic abuse, can often have benefits to the children. How effective are the perpetrator programs? How do their results compare to general anger management courses, or indeed no course at all? Well, you'd be wrong about that. The Ministry of Justice chose to do none of the important things and instead undertook its own processes to count how many people are unhappy they lost their case in court, assume the accusers must be right, ignoring the court determination, which was made after listening to both sides of the story, examining the evidence, and taking professional advice as required, conclude, therefore, that the court must be making the wrong decisions. The government chose to focus overwhelmingly on the adult relationships. The report barely mentions children. And it ignores the actual outcomes for children and actual experts or any real data. This report is a compilation of women's feelings and nothing more. There is not even an attempt at assessing risk of harm, as the title promises. It is important to remember that these cases are protected by extensive confidentiality restrictions, so that you and I only get to see what the Lord Chancellor allows us to see. I can't even tell you about my own case. This is for a very good reason, to protect the children. And we trust the Ministry of Justice to protect our children by controlling this information. But the effect is that the ministry controls a totality of information available to the public, the social workers, the judiciary, and Parliament. This means a decision to provide any information is also a decision to deprive these people of all the other information. The Lord Chancellor thus has a unique control to choose what information his critics hold. And this gives them an extraordinary Soviet-like control over all sides of any public debate on the matter. You and I simply don't have the information to challenge his report or his policies. But this is actually okay. Our free, democratic society still functions if the Lord Chancellor is held to the highest standards of integrity and conduct. But when he decided to publish his report about women's feelings, the Lord Chancellor also decided to deprive us of the real data of what is actually going on in the family courts. What's worse is that the report is informed by the most vociferous and rabid voices agitating for radical change, acting outside of any rules of conduct. Thereby, the agitators have been allowed to gain control of the entire public discourse. The survey process undertaken by the ministry had no control mechanisms whatsoever and would not even amount to qualitative data. It was the most unreliable type of survey there is, an open public call for anonymous responses. It hit all three pillars of bad information. It was voluntary, so only those feeling aggrieved or psychotic are likely to respond. The responses are inherently unreliable. Those that feel aggrieved have already lost their cases in court, so the court has already listened to their story and determined that what they're saying isn't entirely kosher. Why should we trust them now? If angry ex-spouses feel the judgment was unfair, are they right? Should we ask them? Is this good evidence? This is the opposite of good evidence. It is bad evidence. It is provided by people who we know have an axe to grind. The responses are unverified. There is no way to determine whether the respondees ever even attended family court, let alone whether their accounts have any resemblance to the facts. A respondee could have come from another country and we wouldn't know. And we have no idea how many times one person made multiple submissions under aliases. This may go some way to explaining the massive discrepancy in responses. The female to male response ratio was 4-1, even though there's a woman and a man in almost every case. And of course, there are two sides to every story. Even if we agree the facts, our perceptions of them can be different. Imagine the government polled an area that voted 80% Brexit and 20% Remain. Would you rely on their discovery of a problem with immigration? No serious organisation would accept such a flawed attempt at data collection. Any real expert would have identified the imbalance and ruled the data set unrepresentative, but not our panel of so-called experts. The absence of any data control means that we can't identify mendacious agitators within the sample. The panel chose a process most likely to cause harm to genuine victims. The genuine victims are used as a human shield to disguise bad faith responses. This exposes them to the same criticisms I levy at the mendacious agitators. That can't be a pleasant experience, and I sincerely apologise to the genuine victims who are watching this presentation. But I'm afraid I won't take responsibility for it. The government chose this process. And who benefits from this conduct? It's not me. It's certainly not the genuine victims. Only the agitators benefit. So how did such a panel of experts create such an appallingly flawed process? The answer is that there is only one actual expert in this team. It has been filled primarily by lawyers. The doctors and professors in this panel are all doctors of law. The Ministry of Justice should, one would hope, have an abundance of its own lawyers in-house. There was no need for the Lord Chancellor to go outside the ministry for more lawyering. Where are the experts in this panel of experts? There's no scientific expertise. There's no child development psychologist, no criminologist, and no statisticians. A significant number of members had no relevant expertise at all. The panel includes the Women's Aid Lobby, twice. The feminist waiting is an outright embarrassment. It's almost all women, and the two men are both compromised, including, for some reason, the business development director of the perpetrator program accreditor. The government has mistaken vested interest for expertise, and this was not a panel of experts, it was a panel of vested interests. But they certainly have expertise in law, and they know the tricks to play with language. Buried in a footnote is the surprising revelation that perpetrator includes anyone who has been accused of domestic abuse, even after the court has looked at the case and completely exonerated the accused. So the most critical assertion that some form of direct contact between children and perpetrators of domestic abuse was ordered in the great majority of all private law cases, which sounds pretty scary, right? Really means, if we remove the panel's linguistic acrobatics, the great majority, their words, of domestic abuse allegations in private law cases were determined to be either totally unfounded or too trivial to prevent direct contact. Well, doesn't that provide a very different view about what is actually happening in family court? What does that mean for assessing risk of harm? It means that in the great majority of private law cases, the accuser is the abuser. Where a false or trivial allegation is made, the child is separated from the accused but stable parent and left in the sole care of the abusive parent. This cauterization of the child's relationship with a stable and loving parent is harmful to the child and abusive of him or her. And therefore, the great majority of harm to children in private law cases is caused by false or exaggerated claims of domestic abuse. It means that real harm to children is being hidden behind a deceptive linguistic sleight of hand. Who could possibly benefit from this deception? It's not the public or the social workers. It's not the judiciary or parliament. Certainly not the children. The benefit goes only to those vociferous agitators behind the report. This kind of deceptive misconduct is only necessary because things are actually getting better. The domestic abuse industry relies on a feedstock of allegations to drive its economic activity. But domestic violence is down by over 70%. It has halved in the past decade. This parallels the reduction in alcohol consumption across the board, but especially in the 16 to 24 age bracket. This is the age bracket immediately preceding the maturity of the prefrontal cortex, that part of the brain responsible for emotional regulation, and is the age range where most domestic violence occurs. There have been similar declines across all forms of violence and domestic abuse. Imagine you are the CEO of a major company and you saw this graph of your market. You would be in a serious panic mode. The response would be to widen the market. So we have seen domestic violence give way to the broader category of domestic abuse, but this is also crashing. So now we are seeing a shift of focus from incidents to accusations, and in family court, mendacious allegations are rife. This Ministry of Justice report is effectively a marketing strategy for the flailing domestic abuse industry. There is little wonder then at the appalling absence of integrity surrounding the appointment of the literature review author. Our friend Brian Hudson made a Freedom of Information request about this appointment, which is shockingly revealing. What was the job requirements? Information not held. How about the applicant's specification? What kinds of skills or experience did they need? A person experience specification was not provided. Well, how many applicants were there? None. This project was not advertised. Well, can we at least see the statement of impartiality for the appointment? There was none. Yes, there we have it. This is how the Ministry of Justice carefully spends your tax money. And the winner is certainly not you, but rather Dr. Adrienne Barnett. She has no relevant expertise, with a degree in English literature and a Doctor of Law. There's no reason to believe she can even understand technical scientific papers, let alone be trusted to represent them to us. She is yet another lawyer. She is not subject to any professional standards. She is, of course, a radical feminist. And rather than being chosen by a competitive process to find the best candidate, she is a chum of the panel authors. The selection of this critical role in such a sensitive area should have been highly selective to ensure a dedication to impartial, objective reasoning and an absence of gender bias. Presumably, the ministry was won over by Dr. Barnett's public views about science and women, such as the norms of science perpetuate and disguise the myth of superiority of men over women. Quantitative research is based on and validates the masculinist values of neutrality and objective detachment. Universal objective knowledge is masculine knowledge. Objectivity is an undesirable goal. Knowledge production must be useful to women, and this is a mouthful. Concepts of rationality, impartiality, and objectivity are masculinist values which devalue those attributes attributed to the feminine, such as emotions. Whereas Victorian sexism once told us that women were not objective, Dr. Barnett's feminism tells us that women are irrational, emotive creatures. How times have changed. Predictably, Barnett's 200-page so-called literature review failed to cite a single piece of literature that didn't support her conclusions, even though she was reviewing the most contentious issues in family law today. Even pieces that Dr. Barnett did reference were misrepresented to give them an entirely different meaning. We shouldn't be surprised. She told us what she was about. The Lord Chancellor hired her, and she went and did exactly what she said she was going to do. The writers of this report do not value science or even objectivity. They have shown no interest in assessing the risk of harm in family court either. They are quite willing to allow harm to children in order to promote their personal politics. This is critical theory in action. Science observes the real world and develops theories, then continuously tests those theories in the real world to progress our understanding of the universe. Critical theory, however, starts with the author's view of what the world is and what it should be, and develops pseudoscience knowledge products, such as this report, to support activism for change. Adherence to critical theory understands society in terms of power dynamics between oppressor and oppressed, as we heard Dr. Barnett describe science. As such, not only is it acceptable to create misleading information and dress it up as science, it's positively moral. To these activists, science and knowledge are just patriarchal power structures anyway. The wider panel was too compromised to control them. The Lord Chancellor was too gullible to stop them. The report has been applied in the Court of Appeal in the House of Lords as if it were a credible and legitimate output of the state. It is being used to design training programs for frontline staff. Shamefully, when challenged about this, the Lord Chancellor claims he is nothing more than a publisher. Or perhaps he'll publish the famous 5 next to support policy about smuggling in Cornwall. If we want to protect vulnerable children with confidentiality, which I think we all do, but at the same time, we also want to live in a free Western society, which I think we all do, then the officials we trust with the keys to the data need to conduct themselves with exceptional integrity. And we need to hold them accountable if they fail. There is absolutely no integrity in setting up a sham research project and hiding behind structural acrobatics to avoid culpability for it. The Lord Chancellor needs to conduct himself as if he were a part of our free Western society and not like some small-time bureaucrat in a failing Soviet state.